Perfect.
Excellent.
Ready? I'll start with the introductions.
Yes, please.
So thank you everyone for tuning in this evening to the webinar. My name is Michelle Panessa and I'm the Development and Communications Coordinator here at Community Living London. A little bit about our organization. We support around 1,000 people in the local area of all ages with disabilities. We provide numerous and various supports ranging from respite, accommodations, day programs, and programs for youth that have autism. The list goes on. So how we became connected with Kenneth Pope is that we wanted to better communicate about disability estate planning to our families and members. Kenneth Pope since the 1980s has been helping families who are caregivers of children with disabilities on disability estate planning. As you might have heard earlier, if you were tuned in, that Kenneth has been all over Ontario presenting on the topics such as RDSPs, Henson Trust, the list goes on. But as of lately, we've been really fortunate because Kenneth has been hosting more webinars that has been keeping us all up to date on what's been going on with disability estate planning and the changes. So thank you so much, Kenneth, for taking the time for hosting this webinar tonight. I know that we're all very excited to learn more about the topic and also to ask you questions. We really appreciate it.
Thanks, Michelle. I'm glad to be working with you again.
Yeah, it's always a pleasure.
Yeah. Okay, well, I'll start, and I'll just see how my polling is doing. I'll leave it going for a few more minutes, and then we'll close the polling, and I'll show everyone the results. Everyone can see the PowerPoint slides on their screen. You can see that if you look at the picture, you can see I've been practicing for a couple of years, and that's photoshopped a little bit, so and maybe even a little longer. The interesting thing is that approximately 1 family in 10 in the province is the parent household of a child with special needs or disabilities. And you can see here that if the population of the province is approximately 13.7 million, that if you divide that by 3, which is what StatsCan says you do to get the number of households, that you wind up with 4,566,000 households. And if you then look at the figures here, which are as of December 2017, so relatively current, it shows that there are 362,000 people between the ages of 18 and 65 who are on ODSP. Now, that doesn't include all of the children under 18, although there's a small number that are indicated here. Where's the ACSD? Is that on there? No, that's in another presentation. But it doesn't show the children under 18 or the seniors, the adults who are basically the baby boomers who have turned 65 and are older. And this is an interesting development we're seeing these days where people turn 65, they migrate off of ODSP onto old age security and income supplements, which are in fact more than ODSP. So it's an improvement in that sense. But you can see here that if you take the number between 18 to 65, which is 362,000, and then if you're excluding those under and over, that's approximately another third. So let's just say another 100,000. So that would make 462,000 people with special needs compared to 4,566,000. So you can see that that's 10%, 1 in 10, if you look at the number of ODSP households compared to the total number of households. Now, this is phenomenal when you think about it, because who knew? You know, parents with kids with special needs, they may know that there's a support group, and that, I'm just going to turn the polling off, but there's a support group that they take part in, and there are, maybe 20 or 30 families there. But other than that, they feel crazy and alone. So in fact, you're not crazy and alone, and you're in good company. So I stopped the polling.
Okay.
And there's the results.
Cool. Interesting.
Oh, that's excellent. Can everyone see that? So it's interesting, not much from Google, but from our newsletter, we have 9,000 people on our newsletter list. So you would expect that there would be a number from that source. Are there any questions about the percentages? I don't think that's really much, not really a surprise actually. Now, when a child turns 18, if they have disabilities, if they, for example, can't compete in a competitive workplace, or can't function in the, can't handle their own care, or can't function in the community, then they stand to be able to receive provincial disability benefits, which are typically either $8.96 a month or $11.69 a month at present, plus drug and dental coverage. The drug coverage is perfectly fine. The dental is modest, unless you have some special dental needs, in which event, if you have dental work prescribed, then it is possible to get much more radical dental work done. And if you're on ODSP, you can now receive up to $10,000 over 12 months as an occasional gift amount. Used to be $6,000. And the asset test, which used to be $5,000, is now $40,000. So it's certainly improved. The $5,000 asset test hadn't changed since about the year 2000, and the 6,000 over 12-month rule was slightly up from 5,000, which hadn't changed since about 2000 as well. So it was about time for a few improvements. And one other change for those that would find this useful. It used to be that if you were injured in some way, motor vehicle accident, personal injury, the first 100,000 of the tort, the pain and suffering settlement, was exempt. And now it's the whole unlimited amount of the pain and suffering settlement. So this makes a whole lot more sense, in my opinion. I see a couple of questions here. I think I've answered several of them.
Jenny is asking, what are the details of the asset limits? I don't know if that's too vague of a question or.
Well, the asset test is $40,000 of liquid assets. So if you happen to have a TFSA, you can have a TFSA, but it has to stay below 40,000. You could have an RRSP if you happen to be a worker who was injured and now you're on ODSP or applying for ODSP. And you could have an RRSP of up to 40,000. You can have a car, you can have a house. All of these things are in addition to the $40,000. Plus, of course, our RDSPs are fully exempt as well. And yes, about the copy of the PowerPoint, everyone who is registered, we had 408 people register, and everyone who's registered will receive the PowerPoint slides and the YouTube link to the video after the show is over. How many people do we have registered now, Christian?
We have 184 people logged in right now. Okay,
so just slightly less than half of the 408. Yeah, that's about average. Usually it's about 60% that of those who register, about 60% actually take part. Okay, so the next point. Now, people often ask, they've heard that of the 46,000 people who are still living with parents, with family, and receiving the room and board amount of $8.96, they've heard that that other people living at home can receive $11.69, which is true. And this is the difference between the room and board amount and the shelter plus supplementary amount. The shelter plus supplementary amount of $11.69 has a shelter component of $4.96. So what we do is we set up a lease arrangement between the parent and the child, and the parent pays or gives to the parent a shelter component of let's say $5.50 a month. They only receive the $4.96. They don't get the $5.50, but the $5.50 means that as time goes by and as it gets slightly increased every second year or so, that eventually you don't have a situation where the shelter component is greater than the amount actually being received by the parent. And I think obviously this obvious question that everyone asks is, well, do I have to report that as income? Meaning, will it be taxed? And of course, firstly, that would be counterproductive if you had to pay tax on the 550 when you're paying nothing in taxes on whatever share of the room and board amount you're receiving now. So the answer is no. If you're not in pursuit of profit, then you don't declare this money as rental income. And similarly, you can't take off expenses for shelter costs and so on either. This applies not just to your child. It would apply to anyone, anybody who happened to be living with you who was making a contribution towards the shelter costs and was paying less than market, which that's not the sole factor, but if it's less than market, it's obvious that you're not in pursuit of profit. Similarly, you couldn't buy a condo and rent it to anyone at a rate that is below market for more than, say, 3 years, because it would be clear to Canada Revenue that you're clearly not seeking profit, and you must be doing this for some other reason. So as a result, you couldn't write off your expenses either. Similarly, the child who's paying this amount, giving this amount to their parents, can't use it as a rental expense on their tax return. So nothing changes, just that the parents who are helping to administer the room and board amount, and of course don't declare it, nothing changes. It's just that the child is getting $273 more per month, and they're giving $550 to the parents. Are there any questions about that?
There's quite a few, actually. To pick one, John is asking, or no, sorry, Dominic is asking, if we move to a friend or parent's place, are we decreasing from the higher amount back to $869?
No, you'd simply have to have some kind of documentation to show that you're paying $500 or $550 to them for shelter costs, and you'd continue to get the higher amount.
Doreen is asking, did you say that it is possible to own a house or car in addition to having 40,000?
That's correct. You can have 40,000 liquid assets, meaning liquid assets which you could use to support yourself, plus a house, plus a car, plus vacation vehicle. You could even be prescribed a cottage. If you have some anxiety and you find that having a cottage, maybe it's a family inherited cottage, a cottage that you go to with your companion dog, then you could, in addition, it's possible to have that additional property as well.
Allison is asking, how do you change from room and board to shelter scenario?
Well, what we do, and we're always quite transparent with people that contact us or with clients, you need to set up a lease agreement between the child and one of the parents, and to have this an official document. It doesn't have to be in the new prescribed landlord-tenant document that you would have otherwise in the province. You may recall that the prescribed form was changed a year or so ago. Well, we don't have to deal with that. So it could be any kind of a lease document. You can pick one up for Staples. The problem is that when the parents try to do this, once they've seen my videos or spoken with me, the problem is that ODSP definitely tries to stonewall the parents, and they come up with misleading information that if you believed it and relied upon it, you would say, oh, well, I guess I can't do that then. Like they'll tell you that the child has to have a self-contained dwelling unit. Well, this is, of course, not true, because there are people in rooming houses who get the full amount. So, it has nothing to do with a self-contained dwelling unit. Or you reply saying, oh, well, he does. I've fitted up the basement. He has his own bathroom, his own kitchen, his own bedroom. And they would then say, well, have you told the city about that? Or, which of course you don't have to because it's a family member. Although, of course, you should, of course, be cautious of the fire code. That may just make sense. But otherwise, it's a single family dwelling with part of the dwelling fitted up to accommodate a family member. That's all it is. Or what they'll do is they'll try to verify things by trying to speak to the child to see whether the child does his own shopping and cooking, or they'll want to talk to the mother to see whether she makes his food, which of course she does. But and my clients, my client mothers are all honest to a fault. So you have to set things up so that you're speaking the truth, but that even though the child often generally eats with the family, which is perfectly allowable, they can shop and cook. And we walked through a scenario about if your child had a shopping list and you took him to the grocery store, could he fill the cart? Oh, no, he can't read. Well, how about if the shopping list was pictures of the things? Because, of course, the things you get each week, every second week, they're normally the same. Lots of staples. And then can he work at the check? Can he handle the checkout? Because you're at an honest grocery store. Oh, well, no, he's enumerate. Oh, yes, but if he had a debit card, could he punch in the PIN? Oh, yes, he can do that. He does that on his iPad right now. Well, you just make it the same PIN as the iPad. So that's okay. So you drive him home because he doesn't have to be able to drive. Can he unpack? Can he put things in the freezer appropriately? Oh, yeah, no problem. Can he use the stove? Well, we don't let him use the stove, and of course, that may well be prudent, but it may well be just that the parents have just never done it. They've never stopped to develop these life skills. But in lots of cases, I'd say about 95% of these cases, we're successful. And I think part of it comes from the letterhead. It comes from the officiality of it. And also the fact that we've dealt with most of the offices around the province, and they know that we know that they know that we know. So it's fairly simple if you know the rules and you're solid in your knowledge, but otherwise it's very hard for the parents. And what happens is if you get to a situation where the parents have tried and they've been turned down, then it's on the record that they've said no, and it's harder for me to fix it after the fact. But you certainly should, in appropriate cases, try to do it yourself, no question. All right. So the next one is the disability tax credit. And the disability credit applies to the person if they are markedly restricted, take substantially longer, can't set and keep goals, and need constant supervision. It's a very high test. It's higher than ODSP. The test to qualify for ODSP is just that you can't function in a competitive workplace. You may not be markedly restricted, but you can't function in a competitive workplace. So we often do ODSP applications and disability tax credit applications together. It just seems to work that way. And we often use the same doctor. And obviously, if you apply for the disability credit and you're working with the doctor and you're coming up with the clear situation as far as the child's concerned, then it's also workable to have the child approved for the disability, approved for ODSP, because the test is lower than for the disability credit. Now, the great thing about the disability tax credit is that what it does is if your child is over 18, it reduces your taxes by $1,600 a year. If the child is under 18, it reduces your taxes by $2,200 a year. And in addition to the disability credit, there's also the caregiver credit. And I think we'll come to that on another slide. But we often put these together, and you can backfile for a maximum of 10 years, up to 10 years, which is the most common profile is a 10-year backfiling. And the recapture is about $16,000 for the disability credit, which is $1,600 times 10. And if it's for the caregiver credit, the recapture is typically about $7,000 or $8,000. It's a credit that is in transition from a lesser amount to a higher amount. About 7 years ago, it went from $600 a year to $1,000 a year, so that we're still in this transition period. So it's not fully 10,000 just yet. But this is the most common profile we find, is that either the family didn't know about the credit, never used it, or did know, And then when the 85% of the children move out of the home and go either into independent or semi-independent or supported living, many families think that the child has to live with them for them to use the disability credit, which is just not true. The transferability of the disability credit turns on whether you help them, and you always do, whether you help them with the necessities of life, food, shelter, clothing. And it doesn't have to be complete food, shelter, clothing, or even all of one of those things. It could be some groceries on a regular basis, every 2 weeks, let's say. Or it could be a subsidy for rent. It could certainly be buying clothes seasonally. And in that event, the disability credit is transferable to the parent and fileable against their taxes, because of course the disability credit for the child doesn't do the child any good as a tax credit because he doesn't pay taxes. ODSP is not taxable. Any questions about that?
Yeah, Jerry is asking, if a person has been getting the disability tax credit for several years, can they suddenly be turned down on renewal?
I've only heard about that once, and I still don't understand how it can have happened. Normally, the only way that you lose the disability credit is if the market restriction does actually end, in which event you're supposed to voluntarily stop using it, such as a person who is on life-saving therapy, such as dialysis. Well, if you then get a transplant and you're not on dialysis, then you're not getting life-saving therapy, so you should then cease using it. Or if there was some kind of complete recovery, remission, miracle, then you're supposed to stop using the credit. And you know, if it is true that it did apply, and now the circumstances have completely changed, and the person simply wouldn't qualify, well, bonus, right? This is good, accepting, of course, that you can't use the credit anymore. Now, the other aspect of this, as you can see here, is that it allows you to open a registered disability savings plan. This is the caregiver credit. I'll just give you a moment to look at that. I think the biggest thing about the caregiver credit, before we go on to RDSPs, is that I think this is fascinating. Approximately 13% of all people on ODSP still reside with their parents. It's approximately 46,000 people. So until 2017, because in order for the parent, the sibling, to use the caregiver credit, the child had to live with them, had to reside with them. So it only applied to those people with whom the child, because the credit doesn't kick in until you're over 18, the adult child resided. But in 2017, they changed the line on which you report it. You used to report it on line 315. So they changed it in 2017 to remove the reside with criteria, and they changed it to line 307 if you want to check your tax returns for 2017, 2018.
We have a question about that, actually. Someone is asking how you mentioned at the last webinar that the caregiver credit doesn't require the person with the disability to live with the person claiming it. And they're asking, does that actually cover 2017, or does it start in the 2018 tax year?
No, it covers 2017.
Okay.
So you should, of course, go back and refile, do a T1 adjustment for line 307 for 2017, and you'll get $1,000 back if you paid taxes.
There's another question here about the caregiver credit. They're asking, does it depend on the person with the disability's income, or the person or the caregiver's income?
The person with the disability. Under the new rules, the financial guideline was slightly less than this prior to 2017, but I won't touch on that right now. As of 2017, the caregiver credit begins to be eroded by the person with the disability's income when it is 22,000 or more. Now, of course, ODSP is 14,000 at max, roughly. If a person was also employed, then of course it is potentially possible that their income from all sources, employment plus ODSP, could be greater than 22,000. That is possible. And that would then erode the availability of this credit for the parent with whom they perhaps used to reside, no longer reside with. So it is a factor, but it's the person who's on ODSP, it's their income that affects the credit. And the fascinating thing for me is that what this means is that as of 2017, all of the 462,000 families who have a child with disabilities who's over 18 by definition, because they're on ODSP, they have to be over 18. Instead of the 13%, 46,000, the 365,000 who still care for their family member, almost all of them, unless they're completely estranged and provide no assistance, which, you know, there are some of those, of course, but it's very few. Approximately 365,000 families now qualify to use the caregiver credit. And what this is instead of the 46,000, it's 365,000, and it reduces taxes for the 365,000 by $1,000 a year. So that's 365,000 times 1,000. That's a big number, right? You can see what the zeros add up to. So this is a big change, and of course, nobody knows about it. So if you know somebody who has a child who has disabilities and no longer lives with the family, then they should check to see if they've used line 307 for 2017, 2018. And this is there's a process. It's a process to put this this credit in place. You have to use line 307. You have to do a Schedule 5. If the child is not approved for the disability credit, there's not, in which case there's nothing on record about the disability. Then you have to provide some kind of written report or letter to document the fact that this child does have such a disability. You can't just just take it. But other than that, other than the fact that there's a process for this, it's not rocket science. And if the disability tax credit is already being used, well, then you don't have to provide the medical backup, and it's quite straightforward to use it. Are there any other questions about that?
Yeah, Jim is asking if the person with the disability moves into a group home full-time, but the parents are still buying clothes and having him over on the weekends, would they still be eligible for the caregiver and disability credits?
Absolutely, absolutely. Because of course, if the child's in a supported living situation, you would typically have the child come to stay with you, perhaps alternate weekends, certainly on holidays, certainly when the community living, for example, home is closed at Christmas, these sorts of things. And of course, you still buy the child clothing, you still take them out for dinner, you still make sure that they're properly fed. So obviously, you are still a caregiver.
Lindsay is also asking if we only have 6 years of back tax returns, would we be able to get the previous 4? I think she's talking about retroactive tax recapture.
Yes, you can get a maximum of 10-year recapture, and you don't need the returns as long as you're content that you did pay taxes in those years. What you need is a T1 adjustment for each of the 10 years. It's filing a T1 adjustment for line 318 or for line 307 or prior to 2016, line 315. And you simply file the T1 adjustments. You don't have to actually have the return. And if it turns out that you didn't actually pay taxes, well, then you don't get anything.
David's asking, is it possible to pass on the disability or caregiver credits to a sister when the parents are retired but still alive?
Definitely, if the sister helps with food, shelter, clothing. And the fact that she has a higher income than the parents doesn't make any difference. The tax reduction is the same for every taxpayer, regardless of whether they are earning $50,000 or $5 million. It's the same amount. It's $1,600. So you don't need to move it because you think that somebody's in a higher bracket and they'll get more. It just doesn't work that way. But of course, there can be scenarios where parents are retired, they're splitting income, they have personal credits, you know, they use the age amount, the pension amount, etc. And maybe they have their own medical expenses. Maybe they don't actually pay taxes. You know, that does happen. So, you know, if that was the scenario, then yes, you'd have to look at whether to transfer it to the sister. And going forward, if you discuss this, for example, and say, oh, well, yeah, but she doesn't do anything for him. Well, start, right? That's a good idea. And what you do, for example, is say the sister lives in British Columbia and her brother is semi-supported in his own apartment, or even lives with the parents, but say he's you know, semi-independent. Well, you know, she could set up an automatic arrangement with the Metro grocery store, and every second week she could order food to be delivered and she could pay for it. And the fact that she has delivered food means that she is helping with necessities. And so she could clearly document the fact that, you don't have to document it, but she could clearly document the fact that she's helping with necessities. And so the transferability of the credit is quite appropriate.
Let's squeeze one more in. Danielle's asking, does the person with disabilities need to be 18 or older in order for the caregiver amount to be claimed?
Yes, they have to be 18 or older. I see one here about, can one parent use both credits? And yes, you can use both credits. So the reason we're spending time on the benefit increases and the disability tax credits and the caregiver credits is that what we always try to do is to find some way to put money into people's pockets first. That just makes sense. And it's always very unfair, I think, for the family to be getting the lesser amount, because it's only the family that gets the lesser amount. If the child's living on his own or is in supported living with community living, then the supporting organization gets the higher amount. It doesn't change anything about the fact whether the food is provided, room and board. It's just the parents who get the lesser amount. And it's interesting as well, because if a child has a gastro tube and is fed with a liquid, well, then the parents aren't feeding him. So that child then gets the higher amount. And I have clients where the child voluntarily, due to physical circumstances, survives on protein drinks. You know, they buy the drink, that supplementary drink, and they feed themselves. Well, they qualify for the higher amount. It's only the family where the mom and dad shop and cook and feed their child that gets the lesser amount. If you took that $273 a month and paid somebody to shop and cook for your kid, well, then they would then qualify for the $273 increase. It's only if mom and dad do this that they don't get the higher amount. So it's obviously inequitable. And as far as the tax credits are concerned, these are tax reductions that you deserve every penny. And if you don't know about it or don't use them, it's really too bad. Now the next thing is registered disability savings plans. So if you are approved, if the child is approved for the disability tax credit, then they can have a registered disability savings plan. Now the plan can be set up while the child's a minor, in which event the parents are the account holders. And then when the child turns 18, if they're not capable, if they're not competent, the parents continue on as account holders, but the plan belongs to the child. It's not like an RESP that belongs to the parents, but they contribute for the child. And we can get into further discussions about that, but I want to just point out that let's say the child's 18, they're on ODSP, and then based upon their income, not the parents' household income, based upon their income, if someone, they or the parents, contribute $1,500 a year, the government, federal government, puts in a $3,500 grant as a match for the $1,500 plus a $1,000 bond. which you would receive even if you make no contribution. So you put in $1,500, get $4,500, and you do this for 20 years for a maximum of $30,000 from the family and $90,000 from the government. So now 20 years later, the child's 38. They've got $120,000. And if the money had been invested for that 20 years, as it grew at 5%, which is a reasonable amount, at the end of the 20 years, the child's 38, and they have $200,000. And then they have to wait 10 years for the grants and bonds to vest, to be locked in and removable. So now the child's 48, but the money, the 120 invested, 200,000 at the end of the 20 years. Now it's 10 years later, and it's 300,000. So you have a 48-year-old child with $300,000. That's pretty good. Any questions about that?
No.
It's surprising how many people still don't know about RDSPs. We assist people with this stuff all the time, and of course, if the child isn't approved for the disability credit, then of course they can't have a plan. Now, the biggest thing that has happened recently, up until the recent federal budget, if a day came when you no longer qualified for the disability credit, then there was a 5-year period to play with to try to be reapproved. But aside from that, if you weren't approved and didn't get reapproved, you had to give all the grants and bonds back. Well, in the last federal budget, it was proposed, and I presume it'll take effect. Because, of course, even when the Conservatives win in the fall, it was a Conservative Harper government that brought in, Mr. Flaherty, brought in RDSPs back in 2008. So I think it's highly unlikely that anything will change here. But what the Liberal government did in the last budget was it pledged that if a person lost the disability tax credit approval, that they wouldn't lose the grants and bonds that had been received. Up until then, if you lost the disability tax credit approval, then you had to give back all the grants and bonds. But that has now been stopped. So, and that makes a whole lot of sense. As well, there's the factor that you have to wait 10 years from the last contribution. And this isn't just your contributions. This is also the bond, which is paid even if you do nothing. You have to actually manually opt out of the bond contribution as well. But I have clients who, up until then, were making strategic decisions. Like, for example, if you have a daughter with Rett syndrome, unfortunately, you would expect that she might not live as long as other children her age. So you might, at a certain age, cease contributing, stop all contributions, so that you can wait for the 10 years for the grants and bonds to vest, and then start to withdraw. But now you don't have to make that decision.
Donna is asking, can a parent who has not made a contribution to their child's RDSP then make a retroactive one, let's say for 10 years, and have it matched every year by the government?
Well, what you do is, if you can afford it, is you start making retroactive contributions on a 3-year basis. So if the annual amount is $1,500, then 3 years is $4,500. So if you contribute a 3-year contribution to go back 3, then you put it in, you get the grant, you get the bonds anyway. What you then get is the maximum $10,500 grant. So you can pick up 3 years at a time. And if you needed to pick up 10 years, well, then you'd have to do this 3 times at least. And in fact, what you do is you do it 4 times. And what this does is it gives you, you pick up the 10 years, plus you pick up the years that you are contributing in. So if you do 4,500 times 4, you pick up 10 lost years or 10 missing years, plus the 4 years in which you have contributed. And that's a very good thing to do if you can afford it. And what happens is when we get people retroactively approved for the disability credit for 10 years, you can then make the retroactive 10-year contributions to the RDSP. And fortunately, you have the $16,000 that you have collected retroactively, plus perhaps the $7,000 or $8,000 from the caregiver credit. So you have in the range of $23,000 in that kind of perfect world. And all you have to do is contribute $4,500 times 4. So you can see that this is much more doable if we have also done the back filing for the tax credits. And then, of course, you can contribute to the RDSP. Now, if you have, you know, say you get this credit approved finally for a child who is now 18. Well, prior to 18, the grants and bonds would be affected by the household income. So you might not get the bond of $1,000 because that you don't get that after household income is above $24,000. And you might possibly get the grants, the maximum grants of $3,500, because you don't lose those until the household income is over $94,000. So what I'm getting to, working my way forward to say, is that although you might pick up 10 years of the caregiver credit for a minor child, in which event you'd get $22,000, you might well not make retroactive contributions to the child's RDSP. You might just go forward. You might just put $1,500 a year in for 20 years. And of course, it's very, symmetrical in a sense, because the disability credit reduces your taxes by $1,600, and what you need is $1,500 to make the maximum annual contribution. So it's a self-funding arrangement as far as I can see, which I think is absolutely great. Are there any questions about that?
Yeah, someone is asking if a child takes out $300,000 from their RDSP, would ODSP get cut off?
Well, firstly, you can't just do that. I'll talk about the scenario where you could do that, but you can't do that in the normal course. What happens is the child, let's say, turns 49 or 59. All the grants and bonds are vested. It's ready to be paid out. Well, there's a formula for it. And the simple story is that you take the gross amount of the RDSP, all contributions, all growth, and basically it's paid out in equal installments annually over a 23-year period. So that's what actually happens. And depending upon when you start contributing and how much it's invested at and how much you contribute and so on, I did some calculations, and simplistically, again, when you start to withdraw, the child will receive between $8,000 and $12,000 a year for 23 years. Now, we have scenarios, of course, where the child has turned 49, they're 50, and then their aunt, never married, no kids, dies, and her will doesn't have a Henson trust, and they receive $150,000. Well, you could exempt that $150,000 by putting it into an RDSP, because you're approved for the disability credit, and you can still contribute to RDSPs after age 49 up to age 59. You just don't get any grants and bonds. So you could plug that 150 grand into the RDSP, exempt it for ODSP purposes, and then you could withdraw unlimited amounts from it at any time, all of which are exempt. We've done this, obviously. Any other questions about that?
Yeah, Jenny's asking, if a child is now 12 years old, should we be doing the retro in 3-year chunks?
Well, my normal advice is this. No. What you should do is you should simply wait until the child is 18 and on ODSP and in their lowest household income bracket. And then at that point, put $1,500 a year in every year going forward. And over the next 20 years, the child will get all the grants and bonds You'll make a contribution each year that you can afford because now they're living with you to start with at least, and they're getting $11.69 a month. So you can obviously you're receiving $5.50 for shelter from them. So obviously you're now in a better position to contribute the $1,500 a year. And in my experience, if you have a 12-year-old child with special needs, you could have, $4,500 a year lying around. But in most situations, that money is needed for the child for tutoring, camps, respite, all of those things. So my normal advice, except in exceptional circumstances, is to know, just wait till the child's 18. Let's see, what's the next slide? So here's a chart of the contributions and the growth at 5%. Just give you a moment to read that.
I got a good question that just popped in. Brian is asking, would it be better to put money into an RDSP or a Henson trust if you had to choose one or the other?
Well, you don't have to choose because you can have both, and you will have both. The RDSP, hi Brian. The RDSP is the child's plan, and if you make your contributions of $1,500 a year and you get the grants and bonds, this is the child's money. The Henson Trust is designed to receive inheritances from the parents after they passed on. So there are two different sources. It's a common confusion about the Henson Trust and the RDSP. The RDSP can't fall in to the Henson Trust because it's not part of the parent's estate. It belongs to the child. And if the child were to die, God forbid, but we've had this happen. So let's say the child is 35, you've contributed for 10 years, you put $1,500 a year in. Now you've contributed a total of $15,000. The government has contributed $45,000. Then the child passes on. Well, subject to this new ruling in the budget, all the grants and bonds would have to be paid back to the government. And what you'd get back by succession law, presuming that there's no will, is your 15,000 contribution. So they're just not the same game.
She has a message from Kristen.
Jocelyn is asking, what happens to the remainder of the money in the RDSP if the child passes away?
Well, it belongs to the child. It's paid to the child's estate, long story short. And if they have a will, then it goes pursuant to the terms of their will. And if not, then by succession law, it goes back to the parents first, if the parents survive. And if the parents are deceased, then by succession law to their siblings. And if they did have siblings who were deceased but left children, then to their children, their nieces and nephews, and then so on. There's a whole chart for the intestacy tree, or the succession law tree. So it would be, most of these cases would be intestacies because there's no will, and a succession law distribution of the $15,000 or the $20,000. Hi, Fitz James, how you doing? Parents can contribute to adult child's RDSPs and money will not be considered a gift for ODSP purposes. That's true. Let's see what's the next slide. This is just outlining the fact that the grants and bonds are only received until age 49, but you can continue to contribute if you felt like it up to age 59. There's reference here to you putting inheritances into RDSPs. Here's a reference to the budget change, which comes into effect in 2020.
Hey Ken, I've got an interesting question here. If a person is 52 and receiving $900,000 from an insurance settlement, how much can they put in an RDSP to avoid being taken off ODSP?
Well, if they've made no contributions, they're 52, because of course they would have been 42 when these were first set up, and you'd presume that they had made contributions. But if they've made no contributions, then you can put up to 200,000. And if you want to contribute and still leave room for the $30,000 of contributions, say the child is 28, for example, or well, 18, you could contribute up to 170 because you want to leave that 30,000 or whatever that real number is, so that you can continue to make the $1,500 contributions to get the grants and bonds. And in that event, it would be 170.
Lindsay is asking, if the child can't be responsible for their finances, would there have to be a trustee for the RDSP?
Well, at present, if the child is not competent, then the parents can be the account holders when they're over 18. If the child's under 18, then the parent is the account holder because the child's a minor. But if they're over 18 and not competent, then the parent continues on as the account holder. And if they are competent, well, then the child is supposed to become the account holder themselves. And you know, you can hedge your bets if the child is competent by having them sign a power of attorney for property now that they're over 18. And this will allow you to still continue to be the account holder as the personal representative of the child. And you can see that there are scenarios where, for example, a child has a head injury, fetal alcohol effect, mental illness. And one of the real issues to deal with is, you know, sure, we can go ahead and set it up. Maybe we already have when the child's a minor, but now they're an adult and they don't care about the fact that if they take 1,500 out, they lose the 4,500. You know, they don't really care. And if this is the kind of situation that you're in, then you have to have some tactical discussion about how do you protect the child from himself. Now, that's an excellent question to segue. And I'd like to know some vocabularian out there. Why do you pronounce fugue, and segue? You tell me, okay? I'd like to know. So anyway, that's my joviality for the day. So taking control, what's the difference? So you have an RDSP, the child's turning 18, and as far as the institution, the bank, Mackenzie Financial, Investors Group, that has the RDSP, you're concerned that the child will try to raid the RDSP, but the institution is not convinced the child is not competent, just misguided. How do you protect the money? How do you protect the child from himself? Well, you can first start out with the power of attorney if the child is competent enough, perhaps not excessively competent, but that's neither here nor there. A lot of people here will one day be a little less competent than they are now. So you could have powers of attorney for property, and of course you do that for personal care as well. And you could use the power of attorney to try to, like for example, suppose the RDSP was with Investors Group. Then what you'd do is you would have an advisor there, and the child would have to know where the RDSP is. They'd have to know how to contact this institution to get the money, to make a claim to get money. And you'd have to have an advisor who, when they get this claim, calls you first. You just have to be practical so that you can talk the child out of it. But if the child is not competent, on the one hand, you can certainly be the continued account holder. The problem that arises is when the parents, who are the only authorized account holders, die, there is no account holder. So this is what leads you to legal guardianship applications. So you need a trustee in your will to manage the Henson trust for the child, for his inheritance. The RDSP is the child's own property, So in those cases where it's appropriate, you'd need legal guardianship. And normally you start out with the parents as legal guardians together with someone like a sibling of the child, or perhaps a cousin, nieces and nephews, so that when the parents pass on, there is somebody already appointed as a legal guardian to step forward as the personal representative for the child to continue to manage the RDSP. What happens is you need someone to give direction to the financial advisor for the investment of the RDSP. And then one day, of course, payments start. And I've checked, and what would happen is, say it was with a bank, child becomes age 60, the formula kicks in, and the bank would start to issue checks in the formula amount payable directly to the child and mailed to the child's last known address, or whatever address they have on file. Meanwhile, who's going to receive that check? Who's going to cash it? Who's going to deposit it? Who's going to use the money for the child's benefit? Well, this is where the legal guardian who survives the parents comes in. So, and it might well be the same person who is the trustee of the Henson Trust, the sibling, for example. And so what would happen is the sibling who's the trustee of the Henson Trust and the legal guardian would then balance the payments from the RDSP, because they're paid out on a formula, and the withdrawals from the Henson Trust for exceptional needs, or would accumulate. You know, we'll certainly have situations where, you know, between $8,000 and $12,000 a year is being paid out to the name of the not competent child, and you couldn't possibly spend $12,000 a year on them. So of course that money will accumulate, and it'll accumulate and be invested, and that is the estate of the child. And if you presume that the child is not competent to do a will, then when they pass on decades later, there will be an intestacy, and someone will then have to step forward and have a probate application to have a certificate of appointment to become the administrator of this estate without a will. This has never happened before. And then by succession law, if the child had siblings, the parents have predeceased, if the child had siblings, the siblings would receive their estate, which is the $300,000 RDSP, or it would go to their children, the nieces and nephews, if there are nieces and nephews. And then failing that, it goes up the ladder, up the succession law ladder, and potentially to aunts and uncles. And if they're predeceased, because the parents are too, well, then it drops down to the cousins. So, you know, and these cousins, of course, you know, may never, ever have come to visit this child, because, of course, this child was a bit quirky, right? Or maybe they don't even, they live in one side of Canada and the child lives on the other. Or maybe the relatives, the cousins live in England and, you know, have never been to Canada. So it's interesting, but that is definitely how it's going to shake down. Any questions about guardianship and powers of attorney?
There are not.
Right.
No.
Everybody knows all about it.
Still a lot of questions coming in about RDSP.
Okay, well, I'll try a few more.
Okay, Daniel's asking, what happens to the RDSP payments if there's no surviving family member and the trustee is a paid professional?
Well, the paid professional would have to probably become the administrator of the estate of the deceased person, and then they would have to locate, by succession law, whoever it is that's going to stand to inherit the residue of the RDSP. And it could be a very interesting, you know, missing heirs puzzle.
Okay. Anthony is asking, in the case where the holder wants to put the $200,000 limit, should they do $30,000, $1,500 annually first, or can they put the $170,000 lump sum if the child is, example, 28, and then do $1,500 a year to get the grant or bond?
You can do either, but you do want to make sure that you do it so that you preserve the $30,000 contribution space, or however many contributions are left until the child's 49. And then the rest of the money you would put in. Now, the personal asset test is now 40,000. So you could keep 40,000 out to make the 30,000 contributions. And we have lots of clients where the parent who is deceased was not my client while they were alive, so there is no Henson trust. This is a very regular thing on a weekly, once or twice a week, where the parent who wasn't my client is now deceased, and someone calls us, typically the brother, perhaps the executor, sometimes the child who is on ODSP who's going to inherit, and they say, well, I'm coming into $140,000, what do I do? Right, I don't want to lose ODSP, I need the drug coverage. Well, the personal asset test is 40,000, and you can receive from a death up to another 100,000. And if you know how to do it, you can get it exempted from the ODSP asset test, because you're allowed to receive from a death up to 100,000. Now it has to be kept separate and identifiable, and normally it's set up in an ODSP inheritance trust arrangement, and you have a trustee of some sort, although the person could be their own trustee. So you could take these other steps, but if it was decided that you wanted to put the 170,000 directly into the RDSP, keeping in mind that you can't access it until the child is a couple decades older, and when that does start to come out, it's going to come out as part of a formula for payment. If this scenario fits, if the plan is to tie up that money for the long term, and of course we have scenarios where that is the right thing to do, well then yes, you could stick 170 into the RDSP and then basically invest it and forget about it for the next 20 years.
Now we have a bunch of questions coming in.
I see.
Andrew is asking, guardianship applications, do they apply to people under the age of 19 or just adults?
Well, you could apply for guardianship of a minor, but you'd then have to apply again when the child turns 18. So we normally wait until the child turns 18 and apply for guardianship of an adult. And normally, the parents don't have a great deal of difficulty with medical issues. Obviously, they, even when the child turns 18, they can be the ODSP trustee, so you don't need anything for that specifically. They can be the account holders for the RDSP. So again, these aren't big issues at the time, normally for the parent, although we do have clients where, they're just not satisfied that their child who has certain medical illness issues, that they're going to get the right support. There's no question that there's a bias, medical bias. It's part of the triage system, but there's a medical bias against people with disabilities and old people. And basically, the way I describe it is that, they look at it as, if you're a broken bicycle, why fix it? And it's part of the triage system. So it's inherent in the medical process. Like if we can't fix you, go over there. If we think we can fix you, but it'll take a little time, come over here. And if we're sure we can fix you, go over there. But the group that, that's already partly broken, there's no question that there's a bias, that the use of resources for that group is sometimes limited. That's not to say that the doctors and hospitals don't try to do their best, but it's just part of the system. Sometime I'll tell you a story about my dad and a crooked finger he had where they fixed it, but the other hand was, it was a little crooked too. So they fixed the one hand, and I said, well, did you talk to them about the other hand? And he said, oh yeah, they said they could fix it, but it wasn't worth it. He was in his 80s at the time, of course. Well, not worth it to whom?
Yeah.
It's my little rant. Any other questions about this?
Yeah, someone was asking, what's the difference between powers of attorney and guardianship?
Very common question all the time. I'm going to do a video about that. I think I already have done a video about that. You'll see that on my website, actually. So a power of attorney is a document that any competent person can sign. All adults should have them. And they're usually signed when about the time you do your will, normally as part of the package. And it's a granting of a right, an authorization to someone else to help you administer your property or to handle your medical care. But it's a flow of that grant from you to them, and it can be revoked, can be withdrawn. A legal guardianship is an application to the court on behalf of a not competent person, someone who has been assessed and found not competent, to apply to the court to become their legal guardian, their legal representative, and to stand in their shoes. And they have nothing to do with it. Now, you know, the not competent person is still served with the application, the notice that the guardianship application is being made. But of course, you know, they're not competent. And the applications we do across the province are all filed in Ottawa because it's the jurisdiction of the court, not the jurisdiction of a court where you live or they live or, you know, any of those things, the way it would be, for example, for a probate application. So it's a jurisdiction of the court. So we can file them all in Ottawa for people in Sudbury or Windsor or Toronto or it doesn't matter where. And the parent family would typically appoint the parents together with, if you're fortunate enough, one or more siblings of the child because they're of similar age, and if not, perhaps cousins. It could also be the parents plus one of their siblings, an aunt or an uncle of the child, and then also a sibling or perhaps the child of the aunt or uncle. So that what happens is this, it's often not a big problem for the parent. They can often muddle through. They can be the substitute decision maker for health care. They could get the cooperation that they need. You know, maybe they're prepared to muddle through. But when the parents are deceased, it's much harder. Well, is there anyone who steps forward to be the legal guardian? Is there anyone who is a blood relative who in fact could be a substitute decision maker? And if the child is not competent, the adult child, well, how far are the medical authorities going to listen to that other person? I remember when my father was, back in 2011, my dad was 90. He was in the hospital, he wasn't well. And there's me, there's my brother, an engineer, my other brother, a nurse, my sister, and we're all trying to manage his care. And we had a heck of a time. So, you know, how would it be if you have a child with special needs where the system is already slightly biased against him, and the only people that are available to step in are a couple of his cousins? You can see that it would be very difficult to maintain control. Where if they were his legal guardians, then the whole point of informed consent is right on the forefront of this whole thing, because the legal representative stands in the shoes of the child. That's the difference.
Another question, someone is asking, how complex is the guardianship process, and is proving competence through a court case, etc., necessary?
Yes, I'll tell you the process, and it's not cheap. The whole thing winds up being like $8,000. But you have legal fees, you have an application to the court, you have to appear, it's all paper, but you have to have 2 capacity assessments, and the capacity assessors are on a roster from the province. They're legally authorized capacity assessors. They're often geriatric social workers, and they're licensed to do capacity assessments, and you have their fees for 2 of these assessments, and then you have some fees to pay the court and the public guardian for the filing fees and the fee to review the application. And it takes a period of some months, but you know, basically the lawyer preparing this paperwork, it's like a big spiral-bound book with a plan of care, a management plan for property and for personal care. And affidavits and consent forms and people that have to be served and these kinds of things. So it's a legal process. Yeah, I suppose it is, but legally speaking, it is possible for a person to do it themselves. I've never known anyone to do it. You have to have documents that are commissioned and affidavits and so on. So it's a period of time. It has to be done within 6 months because from the day that the capacity assessments are done, you have 6 months to file it, because after the 6 months, they lapse and you'd have to do them again. So it'll be less than a 6-month process, but it's certainly more than 1 or 2 or 3.
I'll give you one more. It's kind of a good one. If parents become the guardians and then they pass away, does the government step in, or is the person left with no guardianship and you have to go through another application?
Well, I have scenarios where there is no one available at all except the parents. And they feel that because of the medical issues, that they need the extra clout that comes with legal guardianship for personal care. And normally the issue is, that issue, but also the continuity transition issue, who will be the guardian after the parents are gone. But we do have scenarios where there is nobody else. So if that's the case, and the guardian is deceased, well, of course, the adult child has been found not competent twice. So in that event, the public guardian and trustee should be notified by somebody, and then they would step forward. Now, the public guardian's office is definitely a last resort. It's not the best choice, but there are scenarios where it is the only choice. So I'd like to look at pensions for a moment. Do we have any more polls to do here?
Yeah, I'll come over there and get another one going.
Okay. If you were a teacher or a municipal employee or a hydro generator worker, Bruce Nuclear, then when you retire, you have a pension. If you're a teacher or a hydro worker, you'll have a good pension. If you're a municipal employee, a less good pension. But the way it works is these are provincial statutory pensions. And you retire, you have a spouse, you die. It's always the guy first, right? And you leave 60% of your pension to your spouse. Then your spouse dies. Well, these pensions also have an adult dependent survivor pension for a child with special needs. So if you, for example, have a child, this is just because it's obvious. If you have a child with special needs who lives with you, well, then they're obviously dependent because you provide them with shelter. But they, the child could be dependent and not live with you. That child stands to receive a 50% of your original pension. So if you're a teacher, you're retired, you have a $60,000 indexed pension, your spouse has predeceased you, then your child, let's say it's a child with Down syndrome and they live with you, well then clearly they're an adult dependent survivor and they would get $30,000 a year. And this brings us to some very interesting factors. Well, firstly, is the child competent to apply for the pension and then to manage it? Because if not, you need somebody to have legal guardianship to do this. And even presuming that they were competent, well, obviously they'll lose ODSP because the $30,000 pension is greater than the $14,000 ODSP amount. And if they happen to be in a supported living situation like Carrie's place and they're not competent, then if their sister is their legal guardian, because the parent, the mom who's the teacher, she's spoken to me and this is the kind of thing that she wants to be taken care of before she dies, not left to her daughter to handle after she's gone. Well, then, of course, you do the guardianship application while mom's alive. She passes on. The sister steps forward. She applies for the pension. She receives it. As guardian, she manages it. But, of course, the child who's at Carrie's place doesn't need and couldn't spend $30,000 a year. Now, I won't get into all the details of what you do in this scenario, but let's just say that the bulk of the 30,000 is not needed and accumulates for the next 20 years. Let's say 15,000 a year accumulates for 20 years. That's 300 grand invested for 20 years. So then what happens is the brother dies, the guardianship ends because it's like a power of attorney. It's only effective while the person is alive. And the sister then, she has been investing this money for all these years, but now she's no longer the legal guardian. So she has to apply for a certificate of appointment, a probate application, to become the administrator of the brother's estate without a will. And then, as the executor, she can then take the money, and by succession law, she's the only other child, so by succession law, she receives it. And here again, this has never happened before. Very rare, but it will become much more common. So let's see what this looks like.
So 80% or 86% of people prefer a weekday evening.
Oh, good.
So we got it right, I guess.
Okay, are there any Saturdays?
It says evening on a weekend is 13%.
Not much.
Morning on a weekday, 11. Afternoon on a weekday. So yeah,
morning on a weekend, 9. So
9.
okay, I thought that more people would want to take part on a Saturday morning, but
Yeah.
they don't.
Well,
Now, of course, it's a poll of the people who
are here right now. That's fair.
So there's that.
Yeah.
but so it's clearly their preference.
Yeah.
Anyway.
Okay, I'm gonna launch the last poll and then that's it.
Okay.
Okay. Here we go. I did notice a question relevant to what you were just talking about before I came over on this side. This one. If a child is eligible to a portion of your pension, does it impact RDSP?
Doesn't affect the RDSP, Brian. They receive the pension. Granted, they lose ODSP, but the RDSP is their property, and any payments under the RDSP is just a return of their money. So it doesn't affect the pension, and the pension doesn't affect the RDSP. And then, of course, if the pension exceeds ODSP and they've lost ODSP, well, although the RDSP payments are exempt anyway for ODSP, well, that's immaterial now because they don't receive ODSP. But the interesting thing for me is that this provision has been in place for quite some time. I do have some much older teacher clients who retired when this provision didn't apply. And if you retired, then of course you get the bucket of pension arrangements that applies when you retire. And if the changes were made after you retire, then of course that doesn't apply to your child. But those are my older teacher clients.
Fitz James is asking, can pension pass to the child after the spousal pension ends?
Yes, after the spousal pension ends. Now this brings us to wills and trusts. Wills with Henson Trust. The Henson Trust, of course, is the most powerful type of trust for the child. We'll get to the aspects of it in a moment. And I see that we're approaching 8:30. I'll ask a question, or maybe we'll do a poll. People, of course, who want to leave at 8:30 can leave, and I guess that'll show us people leaving. We'll have the number 173 participants. So I guess after 8:30, if a lot of people have to leave, well, then they'll leave, and we'll know that. But I'll try to wrap things up without too much delay. Wills and Henson Trust. The trust is designed on the one hand because the heir, the beneficiary, typically can't manage the inheritance themselves. It may be simply that they're unsophisticated, but otherwise competent. But most often, it's a factor of cognitive ability, say for roughly a third, or mental health issues for another third, or for those people who purely have physical disabilities, well, they are still just as able to be scammed or tricked or bamboozled as anyone else. And so it's to protect the person if they can't manage the trust or the fund, or to protect them if they might be taken care of. Or, for example, suppose they were to marry. Well, if the money's in the trust, if the person marries and then divorces, it's not a divisible asset, which is, useful. But then besides that, it also protects ODSP because the unlimited amount that's in the Henson Trust received from the inheritance is completely exempt from the ODSP asset test. And I won't go into it in detail right now, but the disbursements from the Henson Trust are also essentially unlimited and will have a minimal effect, very minor effect on ODSP, and in practice have no effect on ODSP except a very minor effect. So it's a perfect vehicle, and it's a wonderful investment vehicle in a sense. I regularly have discussions with clients who say, well, how much should I leave for them? What proportion of my estate? Well, of course, if you are one of the lucky few who have been able to make that transition for your child already, they're in their own supported living situation, their own semi-independent living, the amount of financial support that you need to give them, the amount of clothing support, those sorts of things, if that is already stabilized, well, then you have a pretty good idea of what kind of support they're going to need financially on an ongoing basis. And this might give you some guidance as to how much to put in the trust. But even if you don't, the discussion I had with a family, I've had this all the time, but it's just this afternoon. There's 4 children. One is predeceased. One of them has Parkinson's, the oldest one. And then one of them has mental health issues and addiction issues. Well, there's a discussion. Do you divide it 4 ways? Do you leave 1/4 to the children of the deceased son, and then the other 3 get their equal shares? Or do you leave 1/3 or half to the trust for the one boy with disabilities, and then divide the rest between the other 3? Or do you pick a number? Say the estate is $1 million. Do you pick $350,000 as a bequest for that one child's trust, and then divide the rest by 3? What do you do? Well, the interesting thing is that in a lot of these scenarios, the child is in a supported living environment, and their needs are extremely modest. And if you put like $300,000 into this trust, and it's more than they need, and the income is in fact more than they need, well, then it accumulates, but it accumulates tax-free, because if you had $300,000 invested at 5%, it generates 15 grand a year. Well, that beneficiary, who happens to qualify for the disability tax credit, you attribute the 15,000 income to that child, and he has $20,000 of tax credits. So the 15,000 is never taxed, or not, there's no tax owing, because the credits exceed the income. And that child, of the $15,000 after tax, at most, he needs $5,000 a year, let's say. Well, the $10,000 accumulates for the next 20 years. And then when that child dies, because they will eventually, the trust itself has a residue distribution clause, and it provides that what's left in that trust, which is accumulated tax-free, then goes to his siblings, if they're alive, and failing that, to their children, the nieces and nephews. So in a lot of these cases, what will happen, in this particular case, this child with disabilities is the youngest of all of the 4 children, one of whom is already deceased. So if he survives all of the children, the other 3, the other 2 surviving, then the residue of the trust goes to all the grandchildren, his nieces and nephews. So he passes on, and it's a gift from Uncle Billy to his nieces and nephews, who are, by that time, presently they're 15 to 19. By that time, they're 20 years older, and it's a delayed inheritance to the grandchildren. So it's a very interesting scenario. Funding trusts with life insurance. Here's the wording two of the specific words that are needed, or phrases that are needed for Henson Trust: absolute and unfettered discretion and shall not vest. That's LETs. I'll come back to that. This is funding insurance, funding trust with insurance. If you're a surviving mother, for example, age 50, non-smoker, you have a life expectancy of 35 more years at least. If you bought yourself a universal life policy that paid 100 grand to the trust for your son, the monthly premium is 115,000. The annual premium is 1,384. Now, if you divide the annual premium into the 100,000, as you can see here at the bottom, you'd have to save 1,384 for 72 years before you had 100,000. Meanwhile, you're only going to live 35 more years. So you could never accumulate that much money. So this is probably the cheapest way to create an estate for a modest household. Often you find that a young couple of 2 or 3 children, one of them, perhaps 2 of them, have disabilities. They need all the money they have to provide for the kids. They may perhaps own a home, possibly, but if they were to pass on, their estate is pretty modest. This is obviously the simplest and cheapest way to create an estate, even if all you do is use it to fund the trust for the child with special needs, and then the other kids share equally whatever the rest is. You can see that this will provide peace of mind for a lot of families. So let's go back. Any questions about life insurance?
Not life insurance, but we have some Henson Trust questions here.
Okay.
I'll start with Andrew's question. He's asking, can a single testator create multiple Henson Trusts with multiple trustees for the same beneficiary?
Say that again.
Can a single testator create multiple Henson Trusts with multiple trustees for the same beneficiary?
You can. I'll give you the answer. Yes, you can. But you'd have to be careful to make sufficient differences in these trusts such that for Canada revenue taxation purposes, they weren't deemed to merge the income. Now, this used to be a technique that people did use because each trust was taxed at a separate marginal rate. So you had these multiple trusts with multiple amounts of money, each of which generated income, each of which was taxed at the lowest marginal rate of 22%. And so the reason you didn't want the income to merge, and you wanted to have each of these trusts sufficiently distinct to see that it didn't merge, was because, of course, this would raise the deemed accumulated income, and you'd eventually come up into the higher tax brackets. But this is no longer a material tactic, because the taxation of these trusts, all of the income of each of these trusts, if it were taxed in the hands of the trust itself, every dollar is taxed at the top rate of approximately 50%. So you obviously have to attribute all the income to the beneficiary to make use of his initial personal credit of $12,000 and the disability credit of $8,400. And if as a result you're simply attributing income to a single person, a beneficiary, from multiple trusts, there's no advantage. So the multiple trust tactic isn't really of much use anymore. I suppose if we struggled with this long enough, we could come up with some scenario where it is still a useful tool. I mean, obviously struggling with it, you could see that if you had 6 separate trusts and the same beneficiary, but the plan was that on his death, each of the trust residue was paid to 6 different people rather than a single trust, and upon his death, 6 people get their share, and I'm not sure just what the advantage of this is, then you can see that you could fabricate some scenario that it might be useful, but I don't see what it would be. As far as lifetime benefits trust, I'd like to touch on that for a moment. The way this works is there will be a lot of people who have sizable RRSPs, or they turn 71 and they become Riffs, and their spouse has predeceased them, and that's why they have a bigger Riff. And if they die, the Riff falls into their estate and is taxed at the top marginal rate in practice in these situations, so they lose half of it. You can see in this scenario here that it's a Riff of 500,000, and if it simply falls into an estate, it's taxed 50%. You lose 250,000, and you have 250,000 left, and that's it. If instead you set up a lifetime benefits trust, you have 500,000, and this trust is specifically designed to receive registered funds. So it receives the $500,000 RIF on a rollover basis, just as it would to a spouse. It doesn't fall into income. The trustee of this trust can only do one thing. They must buy a qualifying trust annuity, $500,000 annuity, based on the estimated lifespan of the beneficiary of this trust. And you can see that the presumption here is that when the parents die, the child is 58. And so you invest the $500,000 in an annuity. It pays $24,864 a year. This $24,000 is paid to the trust, but the income is automatically declared in the hands of the beneficiary, the child. And he has, these numbers are slightly outdated, he has roughly a $20,000 tax credit. So what this means is that the 20,000 is not taxed. In this scenario, well, we'll play with this scenario. You can see here that the numbers that were used, this number is about a year or so old, is 11,600 plus 8,400 for the disability credit. That's a total of $20,000 of credits. So 20,000 of the 24,864 is not taxed. 4,864 is taxed, and it's taxed at 22%, which is $1,070 a year. And since this annuity has a guarantee period of 20 years, to guarantee 24,000 times 20 is 500,000. So it guarantees that the 500,000 is all paid to the trust, even if the child dies prematurely. So calculating over 20 years works out to be taxes of $21,401 instead of $250,000, a savings of $228,598. So you can see this is obviously a better scenario than losing half of it and then letting the residue go to the Henson Trust. You can see here that we're dealing with a smaller amount, perhaps more common, 275,000. You lose 137, leaves you 137. So instead, you give the 275,000 to the trustee of the Lifetime Benefits Trust. You guarantee the annuity for 21 years. It pays $13,200 a year times 21. The first 20,000 is not taxed, so nothing is taxed. 0, 0, 0. So instead of paying $137,500 in taxes, you pay 0 for a savings of $137,500. This has to be better. Any questions about that?
Yeah, Richard Moore is asking, can you transfer a RIF into an RDSP, and would that be better than using a lifetime benefits trust?
Well, I'll give you a simple answer. And the simple answer is yes, you could, but only 170,000 of it, or if the child's over 49, a maximum of 200,000. And I have a scenario like this for a family right now where the mother's predeceased, father has a RIF. It's not a large RIF. And the son is presently 56. Well, if the dad, what the dad's done is he's designated the RIF to the son who's 56. Now what this means, because you can only contribute to RDSPs until you're 59, is that dad has to die in 3 years. If he doesn't die in 3 years, then he has to come back to me and talk about his tactic again, because his son can no longer contribute his RIF to the RDSP after the son turns 59. But simplistically, yes, you could give to the child $170,000 if you have contributed $30,000, or if you have made no contributions and the child is over 49, you could give them $200,000, and this could be an answer. And there's a couple of factors. Is the child competent to receive the RIF? What happens is this: you designate the RIF to the child. You don't designate it to the RDSP. You designate it to the child. The child must then elect to receive it on a rollover basis. Otherwise, he gets all the money. He gets the $200,000 cash, and the estate still pays the taxes. So he has to consent, or someone, his legal guardian, has to consent to it rolling over to him. And then there's paperwork for him to contribute it to the RDSP. And then, if it is contributed, let's say it was contributed in the child's 48th year, well, you still can't take anything out, because you have to wait 10 years, because if you try to take something out, well, then you'll still lose grants and bonds. So it is a tool you could use in the right scenario. But as I say, with this one dad, I'm just sitting here waiting. If he dies within the 3 years, it's all good. If he doesn't die, and his son turns 60, well, he could still leave it to the son, but the son does not have cognitive disabilities, so it can't roll over to him directly. It's only in the RDSP scenario that it could go to the kid and then to the RDSP. And this boy, well, he'll be 60, right? If the dad lives long enough. And he doesn't have any cognitive disabilities, so it wouldn't roll to him. So there's no tax savings. It's just that the kid gets the $200,000 directly. And he's 60, right? He can no longer contribute it to the RDSP. And so he's 60, he's still on ODSP, and he has a $200,000 asset. And the estate still pays the taxes. So I'm not just sure what the advantage of this is. I have a poll here that I'm going to end the polling. Can you see that now there? You have to post it?
Yeah.
Or share results?
Click share.
Oh, good. Okay, thanks.
There we go. Oh, look at that. Wills and Henson Trust. Big surprise.
That's true. Big surprise.
Whenever you're done, you just click stop share.
Oh, you know, more people were interested in the Lifetime Benefits Trust than I anticipated.
Oh.
You know, it's fascinating. I'll shut up here in a moment, and I'll let you go home. You are home. I'm not home. It's fascinating to me because obviously, if you're a person who has a reasonably sizable RIF, and you think that you're not going to draw upon it to help to support yourself, and thereby reduce it to nothing. So you're expecting it will continue to grow, even though as a RIF, you have to take portions out. My experience is twofold. One is that even though you're taking the required formula amount out and declaring it as income, if the RIF is invested, it often grows and doesn't just reduce bump like that. And the other factor is that if you're a person who has a reasonable sized RIF and adequate other income, such that you don't necessarily have to draw upon the RIF to survive, well, firstly, you know, that's a good scenario. You've obviously done something right, and you're probably reasonably astute. And what I found fascinating was that I've been tracking LBTs since 2003, when the legislation first came into place, but it wasn't given royal assent until 2013. And we could have done it before that. Finance says that if you have a money bill like this, that you're supposed to act as if it has received final assent. But you know, so we could have done it, but we didn't prior to 2013. But the fascinating thing for me was that when I first started explaining it to clients, they know they're going to die. They know that they're in practice going to lose half of their RIF, and they know that they don't want this to happen. But they weren't prepared to go ahead with the lifetime benefits trust and the annuity until I pointed out what I would obviously have done, but until I pointed out that there was a guarantee built in, so that even if the child predeceased, so dad dies, LBT is set up, annuity is set up, child receives the money, and then 2 years later the child dies. Well, obviously, if you don't have a guarantee period on the annuity, well then the annuity is over and the insurance company wins, right? And who wants that? So you build in a guarantee period, and as you can see from my examples here, or they'll go back one. You can see here that we've built in a 20-year guarantee period so that we can be sure that even if the child dies prematurely, the trust gets all the money. Well, my clients psychologically would not proceed with these things, even in the face of the fact that they knew they would one day die and they knew that they would lose half of the RIF until I pointed out the guarantee period. And I think this is a good indication of the astuteness of my clients. And as you can expect, it's always a pleasure to work with them. I want to point out one thing. Although there were changes to the use of inter vivus trusts to hold homes for people with special needs, a couple years ago, because of all the kerfuffle in British Columbia, inter vivus trusts no longer could own homes. They could own homes, but if the beneficiary lived in them, they no longer qualified as a principal residence if it was a trust set up while alive. This still works for testamentary trusts and wills, so it's still quite viable to have your Henson trust in your will purchase or receive a home for the child. And if the child lives in it, it does qualify for the principal residence capital gains exemption, meaning that, say you have a condo that your child lives in, you purchased it, it's technically a rental property. Yes, when you die, there's a deemed disposition, there's capital gains, and so on. But if at that time, this property in which your child lives, if it is left to his Henson trust, it then becomes his principal residence. And from then on, until he passes on, and the house is sold, it's a principal residence capital gains tax-free. So it's an investment tax-free that carries on for, let's say, the next 20 years. And then when it's eventually sold, it's sold tax-free, and the proceeds are paid to the siblings or to their children. So you can see this is an excellent investment. And also, by the way, it provides a suitable, safe, secure, clean shelter for the child. And of course, they've learned to live semi-independently. They perhaps get some supports. Perhaps you've arranged for a personal support worker to help, and you have arranged for housekeeping a couple times a month. So this can be a really good thing. And the other big thing is that the taxation of trusts was changed. It used to be that a testamentary trust, its own income declared in its own hands, was taxed at marginal rates, 22% on the first 45,000, 33% on the next 45, and so on. Well, now all income declared in the hands of the testamentary trust, all trusts, is taxed at the top marginal rate, which in Ontario is slightly more than 50%. So of course you have to declare income in the hands of the beneficiary to use their personal tax credits and to reduce taxation. And it has to be done in a way such that it doesn't affect ODSP. Fortunately, this can be done, especially if the beneficiary of the trust qualifies for the disability tax credit. You simply attribute the income to them. You don't actually give it to them, but you declare it on their tax return and you zero it out on the trust return. Let's see what else is going on here. Well, I guess that's about it. I have a number of videos on my website if you'd like to see short 3-minute pieces on various topics that we've already discussed. I'm always adding new videos. There's about 6 more that'll be put up there in the next few weeks.
Ken, there's a question I've seen a couple times in different variations, but is Henson Trusts recognized in other countries?
Other countries?
Yeah. Do you know?
Well, it would certainly be workable in all Commonwealth countries. In the States, they have special needs trusts that are not Henson trusts, but they are trusts that are provincial statutory trusts, state statutory trusts that that allow special needs trusts to be set up. In some of them, you can have unlimited amounts and you can make unlimited disbursements, but whatever is left when the kid dies has to go to the state to offset the money the state has paid for their benefits, and in others you don't. I'm going to do a conference in Barbados, which is of course a Commonwealth country, to talk about the use of Henson Trust. They would certainly apply in Barbados, and I know that, well, if you go to my website, you'll see the history of Henson Trust. There's a 3-minute video, and what it does is it talks about the use of Henson Trust, which are named after Mr. Henson's case down in Guelph, Ontario back in 85, 87, 89. But the actual common law behind these trusts comes from feudal England. And I did a trust for a woman in England one time. She was married to a law lord over there, and she has a son. She has a daughter there with grandchildren and a son here with schizophrenia. And so she happened to be in town because her husband was speaking at law school at U of O. So we met and discussed things. And then I guided her solicitors from England. And I said, well, here's the kind of thing you need. And they sent me, it was a few years ago now, but we had email. And they said, well, here's what we were going to do. And sure enough, it was the proper wording for a Henson Trust. Of course, it's not called a Henson Trust over there because Mr. Henson died in Ontario. But I'll give you the short story. It's a Vow of Poverty Trust. And the reason it works is that if you were in a holy order that had vows of poverty, if you received anything, you had to give it to the holy order. So people didn't really want to do that. They wanted this inheritance to be used for the child in holy orders. It could be a son or a daughter. That wasn't just women in holy orders. And it was a very standard vocation at the time in the Middle Ages. It was an honored vocation. And so you wanted a trust that if you left money to it, wouldn't have to be given to the order. And that, in fact, is what these the Henson Trusts are. They're Vow of Poverty Trusts. I did a bit of research, and I think it's fascinating because the Vow of Poverty Trust means that you have to be in poverty. And these trusts are supposed to allow you to be legally in poverty, but to have this trust to provide anything for you. And that, of course, is really the root of the situation in Ontario and all the other provinces. The Henson Trust means that you don't have an asset and you have no control over how the money is spent to provide for you, because you have to be essentially in poverty to receive provincial benefits. Now, they've just recently, as of September 1st, 2017, increased the asset test from 5,000 to 40,000. So, I guess you're slightly less in poverty. But $11.69 a month is probably poverty level, given that it's about $14,000 a year, and old age security and guaranteed income supplements alone are about $17,400. So when a person turns 65 and gets old age security and GIS instead of ODSP, well, they're slightly better off. How about that? So anyway, that's the short story. These are basically called Henson Trust after Mr. Henson, who died. And there's more of the story in the video on my website. But they are, in fact, Vow of Poverty Trust. I think we better wrap this up. It's 5 to 9.
Yeah, I think so.
See if there's any. Oh, this is a good one. Are the limits under ODSP still $100,000 for a Henson Trust? This is a very common misconception. A Henson Trust has no limit as to the amount of the trust. However, if you don't have a Henson Trust, well then yes, there is a $100,000 limit under the ODSP guidelines. So it's only Henson Trusts that have no limitation. And I think that's probably the final word. What do you think, Michelle?
Well, thank you so much for hosting this webinar. I think it was wonderful. You covered a lot and a lot of great questions. We still are at over 100 participants, which is fantastic.
Yeah, that's true. Yeah, I've got 130 people still here.
Yeah, it's amazing.
It's pretty good.
Absolutely. Well, hopefully we can do this again, because I think this is a great learning opportunity for so many people. And like you said, it's crazy how many people don't know about disability estate planning, Henson trusts, and so on.
It's amazing.
Mm-hmm.
And I just wanted to also mention there's over 100 questions we didn't get to, so I apologize for the people that didn't get their questions answered.
Yeah.
But obviously, you're always feel free to reach out, and we'll be happy to, you know, chat further about it.
And if you want to send those questions to the office, send them to Karen with a K at kpopelaw.ca.
Are you kidding me?
Karen is in the other room. Okay. Thank you very much. Good night, guys.
Good night, guys.
Bye.
Dead.